Anyway, Dr. Thorne is going to talk to you about computer-generated software that's used for evaluating claims. We're now moving from you have all this evidence. You've done your intake, you've interviewed your client, you've got the medical reports, and now you're ready to do the most important thing that a plaintiff's lawyer and a defense lawyer can do, which is to settle the case. Because keep in mind, as long as you are settling the case, you control the outcome. When it goes to a jury, when it goes to an arbitrator, you have lost control of the outcome. So settlement is vital. And what we're going to do is we're going to cover the mechanics of settlement sort of quickly, because they're not really that complicated. And then what we're going to do is go down the panel here, and each one of us is going to chime in and give you a couple of practical tips that we think helps you settle cases from the defense perspective and from the plaintiff's perspective. If you come away from this with nothing else today, I want you to know not only how to get a case settled, but what the other half goes through, which is why we're very lucky today to have a representative from the insurance industry here today who's going to tell you what goes on inside an insurance company and how is authority achieved. You've got defense lawyers here who can tell you that, and you've got plaintiffs lawyers that can tell you the pressures that we have. So you need to understand how the other half lives. Go ahead, Dr.
Thank you, Jim. Just one quick comment. Being the only medical provider in a room full of jurists and lawyers and judges, I've been called a civilian hack.
You're not a defense doctor, don't worry.
All due respect, and actually, I don't think that's all too bad. I think it could have been a lot worse, because I've been a chiropractor for almost 35 years, and I haven't even heard the word quack. So I mean, I'm doing okay with the civilian hack thing. Anyway, you know, I do appreciate the opportunity to be in this room, because I don't know how much you all are learning, but I can tell you I'm learning a tremendous amount. And although I've heard it in some private conversations and many times being deposed and on the witness stand, anytime we come to these meetings, there is just a wealth of information and experience here, and I appreciate being invited into this arena, and I thank you, Jim, for that very much. Anyway, we're going to talk a little bit about the term is coined Colossus, but it really does talk about a number of software products that have been incorporated by the payers, the carriers, to evaluate claims. And basically the definition is it's a knowledge-based system for assessing general damages for bodily claims. There's a little bit of a background here. In the what has been referred to here on a number of occasions as the good old days, there was typically a formula that settled cases at 3-time specials. And I think most of you know what that means. That doesn't seem to be the case anymore. And part of the background to that is the insurance carriers, like any other business, needed and demanded to reduce their costs. And so costs come to any business by several avenues. Certainly claims payment from an insurance carrier is one of their costs, and then payment of salaries and benefits to a legion of thousands of employees and claims reps and claims adjusters. So the strategy, in essence, was to increase profits by, one, cutting out the claimant's lawyers and rushing to the claimant to settle the case for less money prior to the claimant having an opportunity to hire a plaintiff's attorney. And rather than pay $9,000 on $3,000 worth of specials, would go to the claimant and cut a check for $6,000, in essence saving a full 1/3 of the payment. And then it became market. In other words, dollars go where they're treated the best, and when claims that should be settling or had settled in the past historically for $9,000 end up settling for $6,000, there's an argument that says, well, that's the market. And so even if a lawyer is involved, now your fee comes out of $6,000 versus $9,000. So the insurance companies figured there would be an increased litigation, but the overall savings of trying to save 1/3 of their outlay in claims paid would certainly far outweigh that. One way to save some money. The second way would be to take and through attrition eliminate senior claims representatives and adjusters, either through retirement or through attrition. And these folks were then either retired or given early retirement. And in order to replace that, there had to be something that could create a situation where a claims rep could handle more cases in a more efficient manner. And that's the genesis of some of these software programs. The one that's most famous is Colossus, but there's literally, there's dozens of these programs. And in essence, what happens here is the medical, legal, and the insurance community speak three different languages. So the insurance industry continues to capitalize on that because you all need to understand how to speak the language of the claims rep. So the claims rep can then populate the software in order to get to the next level or the next page. So the key is bringing value drivers out of the medical records. And there are certain keys, key productive terms, key findings in the medical records that allow a claims rep to populate the software to create an evaluation of a claim that potentially takes out the human intuitive adjusting process out of that process. That's the theory. So there's less claims representatives. Each claims rep has a higher stack of claims. They now have software to be able to input findings from the medical records, and it's a valuation that becomes much more rote rather than intuitive and negotiated. So what happens is when you get an offer and you send in a 30 to 50 page demand letter that doesn't necessarily talk about value drivers and emphasize the things that create value necessarily in the claim, there might be a lot of fluff in the demand letter, and so as a result it's difficult to settle. There's frustration, there's anger, and there's a lot more litigation. So the key here is the software is designed to establish the general damages on top of economic damages, void of human intuitive abilities, and the variables weighted in the software are treatment, duration of complaint, disability, and impairment. It's very critical that each injury is an individual diagnosis. In other words, as an example, if your claimant has a neck problem, that's a diagnosed neck injury, and there's also a radiating component to it. In other words, pain down the arm or numbness down the arm or weakness down the arm. And that is only reported as a symptom and not as its own ICD-9 or its own diagnosis. It's not able to be put into the software system. So you're potentially leaving a certain amount of value for your claimant on the table if you don't get the medical records and ferret out these value drivers. And that's just an example. You might say it's a neck strain or a disc problem, and if you don't have the code for a radicular problem or muscle weakness or some other neuropathy, you lose that advantage in the software. So it's very important to take a very thorough history, not only from the healthcare provider's perspective, but certainly your all perspective. And it's important that your claimants tell the doctor, as we've noted a number of times, about everything that they're experiencing. Some may be a diagnosis, some may not be, some may just be a symptom. But it's important for the provider to understand all of the problems and then be able to get them into the medical records so you have something to work with and give your claimant and your client the maximum benefit they can possibly get. The equation can't be manipulated by the claims rep. It's only coming from the supporting medical documentation. So the value drivers need to be in the medical records for the claims rep to be able to populate the software and get to the next level. I liken it to my nephew who sits and plays a video game, and they have to do certain things to get a certain number of points to open up the next window. It's just like any other software. It's intuitive that way. And you can't get from point A to point C without having B. So if B is missing, you're only going to be getting an offer at the level of A, if you can follow that logic. So the claims rep has been trained to search for value drivers. And actually, there's probably 12,000 value drivers. But these are some of the most common. And, range of motion, headache, spasm, dizziness, visual disturbance, sleep disruption, radiating pain, anxiety, etc., and TMJ. These are just some of the most common. Now, again, understand, I don't think medical people created these. These were created by either actuarials or there's companies that developed the software back in the late 90s and early 2000s. So there doesn't always seem to be a rhyme or reason for some of the value drivers. But if they exist and your client is suffering from them, you need to have someone to be able to understand what they're looking for, and if it's there, fine. If it's not there, it's not there. The next thing is duration and range of stabilization. So there's points awarded, for example, for the various length of time that the treatment is rendered. Self-explanatory, 0 through 8. Treatment period, dates, treatment numbers, physician specialty, prognosis. Interestingly enough, if a chiropractor is involved, treatment decreases in value. However, if there is a multidisciplinary approach where there's a medical doctor involved in managing the case, chiropractor rendering treatment as far as rehabilitation, sandwiched by a medical doctor as far as discharge and medically managing the case, the value increases. So these are just some types of things that the average lawyer and or doctor may not be aware of. If there's a gap in treatment, we talked about gaps in treatment earlier, and it was seen as a challenge, let's say. And it is a challenge. But I can tell you, if it's documented properly, you can at least bridge that gap. So, for example, if your client can't get to the doctor or hasn't been to the doctor for whatever reason, they don't have transportation, they went to Atlantic City, whatever the case may be. If the provider up front has given them home care instructions, regimen of activities of daily living, maybe exercise programs, if there have been prescribed medications, maybe some discussion with regard to ice, heat, and ice at home. The claimant, if they're not going to be able to make their care on a regular basis over a period of time, whether it be a week or 2 weeks, or maybe there was a death in the family, they should be instructed to keep a log of what they do to continue their care, taking their medicine on a regular basis, altering their activities of daily living or sleeping positions, whatever the directions may have been given by the provider. And as long as that's documented in the record, it's certainly an argument to say, well, although it wasn't optimum and they weren't to the therapist's office and they might have missed a medical visit, they at least had ongoing care. And from the software's perspective, that addresses a gap in treatment. It's very, very important. Then we go to prognosis, and you'll see A, B, C, D, and E, undetermined, no treatment, recommended, no complaints, complaints, no treatment, etc. And each of the indicators has an increasing weight on value, A through E. The only indicators for prognosis for chiropractic is A through C. But D is allowed if documented by a medical doctor. So again, the interdisciplinary practice model avoids any type of loss of value in the Colossus system. And then we look at impairment rating. Impairment rating is one of the two most powerful factors in the software progression. Impairment is a permanent medical condition, and you can read it there, resulting from trauma, work-related disease, etc. And then disability. Disability explains what your limitations are physically as a result of the impairment. Impairment is a medical condition. Disability is a non-medical assessment. And then obviously pre-existing impairments will be subtracted from current and software values, only the difference. So pre-existing problems become once again preeminent in making sure that they're all identified. The next thing that's evaluated in the software is future treatment needs. It must be documented in the medical record. There's 3 categories: possible, probable, and definite. The software only includes probable and definite. So if your doctor is saying, well, it's possibly this and possibly that, and they're a little wishy-washy about it, there's 0 value. And so it's important to know that. history of treatment or length of treatment. There is an increased value for treatment that goes on beyond 90 days versus 90 days. That seems to be the cutoff. Relative to medication, short-term and long-term cutoff is 30 days. Additional indicators there, as you can see, are various other types of treatment or testing that add value to the software program. At the bottom, you see DUD and LOE. DUD means duties under duress. LOE means loss of enjoyment. Duties under duress is if your client is working, continuing to try to work part-time, limited duty, light duty, whatever, and those activities that are causing duress need to be documented and add value to the claim. Loss of enjoyment, if your husband or wife or mother or father loves to garden, for example, or tinker with a car and the engine and things like that, if they're unable to do those types of things without significant problems, or maybe not at all, again, it should be documented and certainly is a value driver. In conclusion, basically what we're talking about here is the final authority for value in a claim when you're talking about a software is information that comes from the medical record. And it's important that you're aware of it, but it's also important that the providers you use are aware of what drives value in these cases. And if those particular conditions are there, it's a shame if they're missed. And if they're not there, at least you're aware they're not there, and you're not leaving anything on the table for the most part. It also allows you to begin to speak the language of the claims rep. So if you know what the value drivers are, a reasonable question to a claims rep when they're ready to make you an offer is, which part of the medical records were the value drivers that you used in assessing my client? And hopefully they're going to understand that language, and maybe you can talk in the same language and you can actually get some answers. And you may be able to go through those medical records and search out some additional value drivers because now you know a little bit about it. And so that may be where the negotiation takes place, but you're all talking Chinese instead of Chinese and Hindu and English, which is typically what happens between the doctors, the lawyers, and the insurance company. So it's kind of a heightened awareness of how you can generate value in the claim and how you can negotiate or at least communicate some of that additional value. That's just a brief overview of the evaluation process that goes on, maybe net of the human intuitive value. And it's happening more and more these days. Thank you.